Arbitration Act, 1996. It's over 25 years old. The Law Commission have decided that they're going to have a look at it. They're going to have a look at it once, but also twice. We've had 2 consultations going out. The last one was March 2023, so we'll just wait and see what comes out of there. But as far as the issues that arises, we're going to touch on them as we go on. But I want to go way back to the mists of time, back to where all the fun as far as arbitration started. Because one of the things that amazes me about a system which is designed to be flexible, which is designed to be pragmatic, is how excited academics get about it. I was reading one article by an academic who clearly had too much time on his hands, who went way back to try and identify what was the first arbitration. And having done a considerable bit of research, and no doubt charged for it, he identified that the first recorded arbitration was that of the Judgement of Paris. What was this, I asked myself? Having been to school in Scotland, Greek myths was not something which was judged worthy of consideration. So I too looked into this. And if you've ever been at a bad wedding, you'll find this story has a considerable degree of resonance. Because there we were. There's always one member of the family that you really don't want to invite. And in this case, it was Eris. Eris apparently is the goddess of discord. And we've all got a goddess of discord in our lives, haven't we? But Zeus made this fatal mistake of not inviting her to the wedding. And again, we've all had those thoughts going through our mind, but generally we say, surely they'll behave. Surely there'll be no trouble. But oh no, Zeus, being Zeus, decided, I'm not going to invite her. She's not coming. I've seen her on the town many nights before, and she's definitely not coming. And forget Christmas. Christmas was a disaster. So Eris did not get invited. But she turned up anyway. And her little contribution was a golden apple. And on that golden apple, it had the words, to the fairest. So it was thrown into the wedding guests, and there were 3 claimants: Hera, Athena, and Aphrodite. And these 3 parties apparently decided to submit themselves to the very first form of arbitration. I know this is tortuous, but I'm going to shoehorn it in. Known to man. So it was late in the evening when this took place. Hi-ho silver hadn't actually been played, but drink had been taken. There was, on one hand, the report of a strong statement of disagreement. On the other hand, was reported as a drunken Barney. So Zeus decided to step in. The ladies decided to submit to arbitration. And the first problem for Zeus was, well, where is this arbitration taking place? Where is the seat of this arbitration? Now, I've done my research too, and the myth is not particularly clear about where the seat of the arbitration was. But I've managed to track down this slide. Now, this slide is important for 2 reasons. First of all, it's the only visual depiction of this particular myth that I can find in which all the protagonists have all their clothes on. And secondly, it gives us a clue as to where the seat of this arbitration actually was. Because if you look in the background, you can see just in the corner, right far back, the outline of a city. We can see its wonderful domed cathedral. We can see its elegant arching bell tower. Now, opinion is divided on where this actually is. Some people say it was Florence. For my money, it's Middlesbrough. And where else would you go for an arbitration? The UK, known as an arbitration-friendly jurisdiction, of course that's where they'd have their arbitration. And it's just as well they did, because if they didn't, then nothing I say from now on makes any sense whatsoever. Because, of course, Zeus's first problem is, right, has there actually been a valid submission to arbitration? And, of course, English law provides the answer to that. Aeto Eastern and Shell Western Supply. There was no formal commencement of arbitration. There was no formal letter in the first instance. What happened was that there was breach of a loan agreement. Shell had the benefit of an arbitration clause, but before it could do anything, proceedings were issued in Nigeria seeking an injunction to prevent it from bringing this claim to arbitration. So Shell appealed against that injunction, and part of the notice of appeal, it said, this is something which can only be adjudicated upon through the medium of arbitration. It's not justiciable by the courts. It was not a formal commencement of arbitration, but the English court held that actually that's sufficient. It's the message which matters, not the medium. So again, it may have been a drunken Barney, but the three goddesses involved clearly evinced an intention to submit to arbitration. So that is sufficient, provided you're in Middlesbrough. Next question for Zeus is, well, which law applies to the arbitration agreement? Is it the law whatever the main contract is, which could be anything, or is it the law of the seat? And again, because we're in England, we have the Supreme Court authority of ENCA, which came out last year. In 2020. Everyone's still talking about it. They have seldom stopped talking about ENCA. And the Supreme Court really just couldn't quite decide. If the main contract says this main contract is governed by French law, German law, whatever, then the arbitration clause will be governed by that law, if there is a specific choice of law. If there is not, what's the answer? Well, the majority of the Supreme Court says, well, it's the law of the seat, that's the law with the closest connection. But the dissenting minority said, actually, no, it's still the law of the main contract. So hence we have got some competing and very strong judgments. And the Law Commission's proposal is that it be the law of the seat, that there be a single default law subject to, no doubt, considered exceptions. So that's the first thing to bear in mind, is that though the Supreme Court have spoken not with one voice as far as to which law applies, but the Law Commission are considering having a straightforward default rule, law of the seat. Now, because we all know this story, it's clear that confidentiality of this particular arbitration had been waived at some point. And again, the Law Commission considered, well, what's the position about confidentiality? There's nothing in the Arbitration Act itself about confidentiality. But confidentiality is nevertheless implied by law. It can be implied as a matter of implicit term in a contract or similar. But there are exceptions. Wonderfully broad exceptions. For example, where it was reasonably necessary for the protection of the legitimate interests of an arbitrating party, or even a general public interest, its exception itself, depending on which case you read. So for my money, the drunken wedding arbitration of who the fairest of them all was certainly very much in the public interest. And clearly Zeus took that view as well, and that's why it's a story we all know and love today. Next question, choice of arbitrator. Now, there was no way that Zeus himself was actually going to do the arbitration. I mean, can you just imagine the mess that you'd get in after midnight Hi-ho silver has been sung, more drink has been taken, having to make that choice. So Zeus appointed Paris. Paris was the son of the king of Troy. And as far as his own characteristics were concerned, he was a shepherd prince. He certainly had no connection with the goddesses hitherto. So to that extent, he was independent. And that's fine, because those are all legitimate grounds for choices of an arbitrator. But what the Law Commission is concerned with is arbitral appointments generally, because one of the big issues in arbitration is lack of diversity. There is a concern about the fact that many arbitrators appear not to be of such characteristics as actually reflects a functioning democratic society in which we live. And of course, that's important. But of course, on the other hand, arbitration has grown up in a culture where often you do want to discriminate in a very positive way. You will want someone with a nationality, especially in the context of international arbitration, who is not of the same nationality as the parties. So hence the Law Commission's suggestion is this halfway house where appointments should not be susceptible to challenge on the basis of the arbitrator's protected characteristics, and any agreement between the parties in relation to the arbitrator's protected characteristics should not be enforceable unless, in the context of that arbitration, requiring the arbitrator to have that protected characteristic is a proportionate means of achieving a legitimate aim. So if the English, Irishman and the Scotsman walk into the bar and the English and the Irishman have a dispute, then of course they're going to want the Scotsman as a Scotsman to intervene and arbitrate. So that's clearly, I would say, being Scottish, a proportionate means of achieving a legitimate aim, i.e. hopefully arriving in a situation where both parties have confidence in the neutrality of their arbitrator. Fortunately, as far as Zeus was concerned, he didn't have that problem. But it is something which is concerning the Law Commission. Summary judgment. Paris, having been appointed, again, was in a bit of a quandary because this was a difficult gig for him. All sorts of things could go wrong. Now, he could either go for the quick option of a summary judgment, or he could go for the more involved arbitral process that most people accept. Wisely, he avoided the summary judgment option. That was going to lead to death. So what his options were, however, was that there is an implied power of summary judgment already in the rules. Stems from Section 33 of the Act, i.e. adoption of procedures which avoid unnecessary delay and expense. So it's there implicitly in the Act already and has been treated as such. The Law Commission actually want a specific amendment to the Act to allow summary judgment. It's not expected to change matters considerably, but it is, as far as the Law Commission is concerned, part of a tactic, an approach to demonstrate that English law is one of the more arbitral-friendly jurisdictions to arbitrate in. And indeed, as far as the approach of the Law Commission is concerned in summary judgment, they've noted that what's important is that parties have a reasonable opportunity to present their cases. And so far, that sounds fairly straightforward. Until I read in the Law Commission's proposals for consultation, well, what they meant by reasonable opportunity was a situation where parties were not allowed to continue with their arguments interminably until they had exhausted the arbitral tribunal into submission. You can imagine the disappointment with which I read that phrase and realised that is what I'd been doing myself over the past 20 years. So that is summary judgment. Last slide, independence and impartiality. Because we take it for granted as English lawyers that our judges will be independent and impartial. But what the academic commentators get very excited about is this idea of independence, i.e. having no connection with the parties whatsoever. And we're used to being against people in the same chambers or the same firm or other kind of connections that we've had in our professional careers. And judges may be from the same chambers or the same firm. We're used to that. Elsewhere in the world, they're not. So hence they have this issue with independence. And the Arbitration Act doesn't actually deal with independence at all. It deals with impartiality. Because for the UK drafters, impartiality is the key, i.e. not having any interest in the outcome. And this is where Paris came a real cropper, because he was bribed right, left and centre. Hera offered him the kingship of Europe and Asia, pretty impressive. Aphrodite offered him wisdom and skill in the arts of law. And Athena offered him the hand of the most beautiful woman in the world, Helen of Sparta. And Paris, not being one to give up the opportunity, went for Helen of Sparta. So having duly delivered his award, he found out that in terms of getting payment of fees, he was in a bit of a sticky situation because he actually had to go to Sparta, abduct Helen, take her back to Troy, where she promptly became Helen of Troy. And the rest, as we all know, is history. So I commend this story to you. I commend the Law Commission's thoughts and proposals to you. I hope you don't get involved in any arbitrations which involve a wedding, a golden apple, and potentially violent conflict at the end of it. Ladies and gentlemen, thank you.